Welcome to this Nani Palkiwala National Law Club's Nashniwala Nani Palkiwala Jayanti program. We are taking on the occasion of Nani Palkiwala Jayanti, which will be happen on 16th of January 2025. And this will be Nani Palkiwala's 104th or 105th birth anniversary. On this occasion, we have already completed one episode and we are now taking total 8, and 8th is our grand ceremony which will be happen physically. Chief Justice of India or any prominent judge of Supreme Court will preside the chair, and a key speaker will be there and will give some award in that function, like a lifetime achievement award for some senior advocates, and sub junior or arguing counsels we will give some awards of excellence also. So before that, 7 total program we are taking on a webinar, how Nani Palkiwala has contributed in different cases. So the day before yesterday, on I think 28th of December, we have taken the part 1 of this program, and part 1 of first our case, Kesavananda Bharati. And today we are going to see Kesavananda Bharati part 2. So first of all, let me first reiterate the Nani Palkiwala's contribution overall, in short, some points in our legal history as a legal luminary, how he contributed. Nani Palkiwala, born in 1920 and depart from this earth on 2002, was a prominent Indian lawyer, constitutional expert, and legal luminary, best known for his significant contributions to the legal and constitutional framework of India. His impact on the Indian legal system can be summarized as below some keys. 1. Constitutional law expertise. Palkiwala was renowned for his expertise in constitutional law. He played a crucial role in several landmark cases that shaped the interpretation of the Indian Constitution. He argued cases before the Supreme Court, particularly those dealing with fundamental rights and relationship between the judiciary and the executive. 2. Public interest litigation. He was one of the early proponent of public interest litigation in India, which allowed individuals to file petitions in the interest of the public, thereby expanding access to justice. His advocacy for the right of the marginalized and underprivileged has had a profound impact on how judicial process involved in India. 3. Constitutional amendment and challenges. Palkiwala was instrumental in challenging several constitutional amendments that he viewed as detrimental to the basic structure of the Constitution. One of his most notable contribution was during the Kesavananda Bharati case in 1973, where he argued against the Parliament's power to alter the Constitution's basic structure. 4. Influence on economic policies. Beyond constitutional law, Palkiwala was also involved in discussion on economic policies, especially regarding taxation. His book, The Law and Practice of Income Tax, becomes a significant reference point in the field. His understanding of the economic and legal principles highlighted the importance of law in governance and policy formulation. 5th, legal education and advocacy. Palkiwala was a passionate advocate for a legal education in India. He emphasized the need for a well-rounded legal curriculum and was involved in teaching law as various institutions, imparting critical knowledge to future generations of legal professionals. Six, public intellectual and scholar. Apart from his legal practice, Palkhiwala was a prolific writer and public speaker. He wrote extensively on issues of national importance, law, and democracy, contributing to the disclosure around civil liberties and the rule of law in India. His speeches and writings often reflected his concern about the erosion of democratic values and civil rights. Recognition and legacy. Palkhiwala received numerous accolades for his contribution to law and society, including the Padma Vibhushan, India's second highest civilian award. Has his legacy continues to influence legal practitioners, scholars, and activists in India. Friends, I'm continuously following Nani Palkhiwala. I'm continuously following Ramjet Malani, and so many great lawyers. Also, I'm follower of Dr. Babasaheb Ambedkar also. And through my dhyan process early in the morning, I meet all of these peoples and I get enlightened. So I am a eklavya of Nani Palkhiwala in true sense. So friends, let me move for second part. So now I am taking you on page number 327 of original judgment of Kesavananda Bharati, para 581. Earlier some paras were arguments, notations and arguments, information is given. Already I have covered in part 1, now in part 2. In part 2, whatever you will listen and you comes to know that how Palkhiwala has mastered in not only Indian constitution but other constitutions also. So there 581, there seems to be a good deal of substance in the submission of Mr. Palkhiwala that the above decision is based on the multiple on the principle of implied limitation, because otherwise under section 29(1) of the Ceylon Constitution Act, Parliament was competent to make law for the peace and order and good government of the inland subject to the provisions of the orders. Strong observations were made on the true nature and purposes of impugned enactments, and it was said that the alteration made by them in the function and the judiciary constituted a grave and deliberate incursion in the judicial sphere. The following passage is not noteworthy and enlightening. If such act as these were valid, the judicial power could be wholly absorbed by the legislature and taken out by the hands of the judges. It is appreciated that legislature has no such a general intention. It was beset by a grave situation and it took grave measures to deal with it. Thinking one most presume that it has a power to do so and was acting rightly, but that consideration is irrelevant and gives no validity to acts which infringe the Constitution. What is done once, if it be allowed, may be done again and in a lesser crisis and less serious circumstances also. And thus, judicial power may be eroded. Such an erosion is contrary to the clear intention of the Constitution. So, Parliament should not have the power to change the basic structure. To explain all these things, Palkhiwala has given you different type of arguments before the Apex Court in 1973, friends. Now I will take on one more para uh, 292, which will be on page number, which is in on page number 34442, para 592. Mr. Palkhiwala says that decision in US versus WH Sprague Supra has no relevance to the question before us. All that it laid down was that Congress had the sole discretion to decide whether a proposed amendment should be submitted to state legislature and to the state conventions. The language of Article 5 itself shows that sole discretion in this matter is confirmed on the Congress, irrespective of whether the amendment deals with the machinery of government or with the matter affecting the rights and liberties of the citizen. Sprague's case it is suggested, was merely a fresh attempt after the decision of Supreme Court in the state of Rhode Island versus A. Mitchell Palmer 64 LED 946 to argue that the 18th Amendment, which introduced prohibition, was unconstitutional since it was ratified by the state legislature and the attempt rightly failed. For the reasons suggested by Mr. Palkhiwala, which appear to have a good deal of substance, we are unable to deprive any help from US versus WH Sprague. So he tried to give many international citation, international arguments before the Supreme Court. Supreme Court some accept, some they did not think that it is applicable to particular segment. But his perseverance to prove his case is on at a great and on a larger scale also. Now, next. Page number 361, para 614. I'm reading only Nani Palkhiwala's argument and Nani Palkhiwala's contribution in this Kesavananda Bharati case. Total overall democracy, to protect democracy, credit goes to Nani Palkhiwala because of this case only. So after this case, basic structure doctrine comes into existence. Parliament cannot alter the basic structure of the constitution. At that time, whoever may be prime minister, but fails to bring her dictatorship on India. But after that, she filed review petition of this Kesavananda Bharati. Review petition also, Nani Palkhiwala argued very on great energy and with proper points and proper citations. So review petition also dismissed. Then Prime Minister filed another, that government filed another last remedy of Supreme Court, that is curative petition. Curative petition also Nani Palkhiwala argued in open court, and that is also dismissed. And then helplessly that Prime Minister have to impose emergency in 1977. So this is the great task of Nani Palkhiwala, to protect democracy through such landmark case. So now, para 614. According to Mr. Palkhiwala, Article 31C destroyed several essential features of the Constitution. He says that there is a vital distinction between two cases. A, where fundamental rights are amended to permit laws to be validly passed, which would have been void before the amendment. And B, the fundamental rights remain unamended, but the laws which are void are offending those rights are validated by a legal fiction that they shall not be deemed to be void. He further point out that on the analogy of Article 31C, it would be permissible to have an ambiguous article that, notwithstanding anything contained in the Constitution, no law passed by the Parliament and any state legislature shall be deemed to be void on any ground whatsoever. Article 31C, according to him, gives a blank charter not only to Parliament but all the state legislatures to amend the Constitution. On the other hand, the argument on behalf of the respondent in the Article 31C is similar to Article 31A and Article 31B, and that the object of inserting the article is to free certain kind of law from the limitation of legislative power and imposed by the conferment of fundamental right by Part 3 of the Constitution. Now, friends, I will lead to you on para 628 on page number 373. Para 628. The petitioner's learned counsel, Mr. Palkhiwala, advanced twofold argument as to the scope of that article. He first contended was that in the exercise of its power under Article 368 as it stood before its amendment, it was impermissible for Parliament to take away or abridge any of the rights conferred by Part 3 of the Constitution. Part 3 covers entirely fundamental rights, and Part 4 covers a guiding principle, that is, which is a guiding principle which Parliament in future should enact the laws on that. That is called directive principle of state policy, which is given in Part 4. His second and more comprehensive argument was that the power conferred on the Parliament under Article 368 did not permit it to damage or destroy any of the basic or fundamental features or essential elements of the Constitution. The argument on these two aspects naturally ran into each other, but for a proper legal approach, it is necessary to keep them apart as far as possible. Hence, while considering the correctness of the first contention, he shall not take into consideration the importance of the fundamental rights. On this aspect, our approach to Article 368 will be purely based on the language of Article 368 and Article 13. The importance or transcendental character of the fundamental rights, as well as the implied or inherent limitation on the amending power, if any, will be considered while dealing with the second of the two alternative contentions advanced by Mr. Palkhiwala. We shall first take up the question whether by the exercise of power of amendment conferred by the Article 368 as it is originally stood, Parliament could have taken away any of the fundamental right conferred by the Part 3. According to Mr. Palkhiwala, Article 368 as it stood before its amendment merely laid down the procedure for amendment. The power to amend the Constitution must be found somewhere else in the Constitution. The power to exercise by Parliament under Article 368 in the legislative in character, and the resulting product is law. Hence, such a law in view of the Article 13(2), which says that the state shall not make any law which take away or abridges the right conferred by this part, and any law made in contravention of this clause shall to be extended on the contravention be void. Cannot be validly taken away or abridge any of the fundamental rights. He further contended that word law in Article 13(1) means and includes not merely legislative enactments but also constitutional measures. The council argued there is no reason why different meanings should be given to the word law in Article 13(2). A more important argument of his was that the power to amend the constitution, even if it is assumed to be contained in Article 368, is by no means an exclusive power, because in certain respect the subject to certain condition. The constitution can also be amended by the parliament by a simple majority by enacting a law in the same manner as other legislative measures are enacted. In this connection, he drew our attention to Article 4, 169, para 7 of the 5th schedule and paragraph 21 of the 6th schedule. Council argued that if the amendment of the provisions of the Constitution referred to therein is considered as the exercise of the constituent power, and consequently such an amendment is not a law within a meaning of that expression in Article 13, then Parliament, by a simple majority of the members present and voting, if the rule regarding the quorum is satisfied, can take away or abridge any of the fundamental right of the certain sections of the public in this country. Then para 643, we shall now examine the contentions of Mr. Palkhiwala based on Article 4, 169, paragraph 7 of the Schedule 5 and paragraph 21 of the Schedule 6. He contended that we have no doubt that he did not rightly that the Constitution can be amended not only under Article 368 but also under Article 4, Article 169, paragraph 7 of the Schedule 5 and paragraph 21 of the Schedule 6. Amendment under these provisions can be effected by Parliament by a simple majority vote of the members present in the House and voting, and if the prescribed quorum is there, if the two houses do not agree on any amendment under those provisions, the same has to be decided by a joint sitting of two houses as provided in Article 108. That is because of the express exclusion of the application of Article 368 to the amendments made under those provisions. According to Mr. Palkhiwala, by the exercise of its power under the aforementioned provisions, Parliament can in certain respects take away or abridge the fundamental rights of a section of the people of this country. He painted a gloomy picture as to what can happen by exercise of the power by Parliament under those provisions. It is true that the power confirmed under the aforementioned provisions is amending power, but those provisions make it clear that the exercise of the power under those provisions shall not be deemed to the amendment of the Constitution for the purpose of Article 368. Now, we will move towards para 653, which is important. We now come to the second attention of Mr. Palkhiwala that the word amendment has a limited meaning and Article 368 does not permit any damage to or destruction of the basic or fundamental features or essential elements of the Constitution. Mr. Palkhiwala argued that the word amendment or amend ordinarily means to make certain changes or effect some improvement in a text. How beautifully argued. How he explained the word amendment. Word amendment or amend ordinarily means to make a certain changes or effect some improvement in a text. Those words do not, according to him, except under special circumstances, means the widest power to make any or every change in a document, including a power of abrogate or repeal the basic feature of that document. The same he contended in true of the power to amend or amend a statute or a constitution. In support of his contention, he invited our attention to the various meanings given to the word amendment or amend in several dictionaries. He further argued that in construing the meaning of the word amendment in Article 368, we must take into consideration the donee to whom the power to amend the Constitution is granted, the atmosphere in which the Constitution came to be enacted, the consequence of holding that power is unlimited, is scope as well as the scheme of the Constitution. He argued that in the final analysis, the duty of the court is to find out the true intention of the founding father, and therefore the question before us is whether the founding father intended to confirm a parliament, a body constituted under the constitution, power to damage or destroy the very basic on which our constitution was erected. On the other hand, it was contended that on behalf of the Union of India, state of Kerala, as well as other states, that the power of amendment confirmed under Article 368 is of the widest amplitude. It brooks no limitation. It is the power which can be used to preserve the constitution, to destroy and constitution, and to recreate a new constitution. So this is the contention of the respondent. That means Union of India and State of Kerala. It was contended that the society can never be static. Social ideas or political and economical theories go on changing, and every constitution, in order to preserve itself, need to be changed now and then to keep in line with the growth of the society. It was further contended that no generation can impose its will permanently on the future generation. Wise as our founding fathers were, wisdom was not their sole monopoly. They themselves realized it. They knew that in a changing world, there can be a nothing permanent, and therefore, in order to attune the constitution to the changing concept of politics, economics, and social ideas, they provided in Article 368 a machinery which is neither too flexible nor too rigid, and make it possible to be reshape the constitution as to meet the requirement of the time. According to them, by the following the form and manner prescribed in Articles 368, Parliament can exercise the same power which the Constituent Assembly could have exercised. We have now to consider which one of two contention is acceptable. So both contention, earlier I explained the contention of the Nani Palkiwala, and later I explain you the contention of the respondent, state and union. Then para 988. Now he has given the example of different constitutions, so different other countries' decision also. So here are some. Page number 617 and para 988. Mr. Parkiwala relied on some Canadian decisions. No, before that, I will give you some. Before that, I will take a para 853 on page number 580, 538. Para 853. A page number may be a different to in different publishers. So I have taken this PDF from Manupatra. So page number is according to that. Original judgment page number is different, and other SCC maybe page number is different, but para number will be the same. So para 853. Reliance was placed by Mr. Palkhiwala on American jurisprudence, second volume, 16 Article 59 at pp 231-232, Article 72 at page number 251, Article 287 at pp 270-71, and Article 88 at pp 273-74. In support of these propositions, first question of the constitutional construction are in the main governed by the same general principles which control in ascertaining the meaning of all written instruments, particularly statutes. External aid or arbitrary rules implied to the construction of the Constitution are of the uncertain value and should be used with hesitation and circumspection. Second, constitutions are general, and many of the essential with which constitution treat are impliedly controlled or dealt with by them, and implied plays a very important part in constitutional construction. What is implied is as much a part of the instrument as what is expressed. Third, a court may look to the history of the time and examine the state of things existing when the Constitution was framed and adopted. The court should look to the nature and object of the particular power, duties, and rights in question with all the light and aids of the contemporary history. Fourth, proceedings of the conventions and debates are of the limited value as explaining doubts phrases. Similarly, the opinions of the individuals members are seldom considered as of the material value. A little bit tough language is there because this is a para extracted from the American that particular case laws. Further, para 854, Mr. Parkiwala said that the word amend may have three meanings. First, it may mean to improve or better to remove an error. The quality of improvement being considered from the standpoint of the basic philosophy underlying the Constitution. Second, it may mean to make changes which may not fall within the first meaning, but which do not alter or destroy any of the basic essential or any of the essential features of the Constitution. And third, how beautifully he explained the word amend in three ways, which is in sequence to prove that basic structure should not be disturbed. So third, it may mean to make any changes in the constitution, including changes falling outside the second meaning. The first meaning was preferred. The second was said to be possible construction. The third was rule out. Then this is very important uh, on page number 559, para 892. Mr. Parkhiwala enumerated 12 essential features. These are as follows. 1. The supremacy of the Constitution, the sovereignty of India, the integrity of country, the democratic way of life. 5. The republican form of the government. 6. The guarantee of basic human rights elaborated in Part 3 of the Constitution. 7. A secular state. 8. A free and independent judiciary. 9. Dual structure of the union and the state. And 10. The balance between the legislature, the executive, and the judiciary. 11. A parliamentary form of government as distinct from the president form of the government. And 12. Article 368 can be amended but cannot be amended to empower Parliament to alter or destroy any of the essential features of the Constitution. Make the Constitution literally or practically unamendable. Make it generally amendable by a bare majority in Parliament. Confirm the power of amendment either expressly or in effect on the state legislature, and delete the proviso and deprive the state of the power of ratification, which is today available to them in certain broad areas. The Constitution 24th Amendment Act was impeached by Mr. Palkhiwala on 3 grounds. First, by substituting the word amend by way of addition, variation, or repeal. In place of word amendment in Article 368, the power was widened. Second, the 24th Amendment made explicit that when Parliament makes a constitutional amendment under Article 368, it acts in the exercise of constituent power. The third is it had provided by amendment in Article 13 and Article 368 that the power in Article 13.2 against abridging or taking away of the fundamental rights shall not apply to any amendment under Article 368. The Constitution 24th Amendment Act is therefore to be construed as empowering Parliament to exercise full constituent power of the people and to vest in Parliament the ultimate legal sovereignty of the people, and authorizing Parliament to alter or destroy all or any of the essential feature, basic elements, and fundamental principle of the Constitution. Likewise, Parliament is constituted by the Constitution 24th Amendment Act to be authorized to damage or destroy the essence of all or any of the fundamental rights. Therefore, amendment must be illegal and invalid. So that 12 feature, we should protect that 12 feature. So that 12 feature beautifully explained in this para 893. Then para 944. Are fundamental rights unamendable? Mr. Parkhiwala contended that apart from Article 13.2, fundamental rights are based on Universal Declaration of Human Rights. Very good point, friends. How from which document our fundamental right comes into Constitution? So, Universal Declaration of Human Right. And I read same principles which is in Constitution in a Ram Rajya principles. Every Navratra, I have the fast, Maun, and I visited any sacred places. Tap is there, and read different Grantha of our India. I read Quran, I read Bible, I read Gita, I read Ramayana, I read Mahabharata, I read other Grantha like Dasbodh like that. Recently, I read one Granth that is Agni Puran. In Agni Puran, I found all the best principle of Ram Raj, code of conduct of Ram Raj, which is not easily found in Ramayana also. Ramayana story is there, but how Ram Raj was conducted in that era, that I found in Agni Puran in very liberative ways, in a very expletive ways. And I found some in Lagnipura, some principles of property laws. I surprised how our granths are. And all this international convention, human rights, everything is the part of the our Ram Raj. So friends, these universal declaration of the human right and are natural rights, and therefore they are outside the scope of amendment. In Golaknath case, the majority views declined to pronounce any opinion on alleged essential features other than the fundamental rights. The concurring view was that the fundamental rights were unamendable because they were fundamental. Vanchu judge for himself and two other learned judges and Ramaswamy judge rightly rejected the theory of implied limitations. The three reasons given by the Vanchu justice are these. First, the doctrine of essential and non-essential feature would introduce uncertainty. Secondly, constituent power of amendment does not admit any of the impediment or implied restriction. And thirdly, because there is no express limitation, there can be no implied limitation. Then I will take you on para number 988. Mr. Parkhiwala relied on some Canadian decision and initiative and reference case 1919 AC 935, Swissman versus Albin 1957, Canada Law Report 285, Rex versus Hess 1949 4, DLR 199, and Saumur versus City of Quebec and Attorney General of Quebec 1953 for DLR 641, and Chabot versus School of Commissioners of Lambert and Attorney General of Quebec 1958 12 DLR 796 in support of these propositions. First, unlimited legislative jurisdiction of the dominant parliament in Canada is under inherent limitation by reason of the preamble to the British North America Act, which state that the Constitution is similar in the principle of the United Kingdom. Second, the domination legislature cannot detract from the basic right of the freedom and speech and political association which are available in the United Kingdom. Third, the right which find their source in natural law cannot be taken away by positive law. It is the initiative and referendum case, the Judicial Committee said that Section 92 of the British North American Act entrusted legislative power in a province to its legislature and to that legislature only. A power of legislation enjoyed by the provisional legislature in Canada can, while preserving its own capacity intact, seek the assistance of subordinate agencies, as in Hodge versus Queen 9 AC 117, the legislature of Ontario was held to be entitled to entrust to the Board of Commissioner authority to enact regulations. It does not follow that such a legislature can create and endow with its own capacity a legislative power. The initiative and referendum case decided that in the absence of clear and unmistakable languages, the power which the Crown passed through a person directly representing the Crown would not be abrogated. The Lieutenant Governor under the British North American Act, referred to as the BNA Act, was an integral part of the legislature. The Initiative and Referendum Act was found to be one which wholly excluded the Lieutenant Governor from legislative authority. The only power of the veto and disallowance preserved by the Initiative and Referendum Act were related to act of the Legislative Assembly as distinguished from the bill. Therefore, the power of the veto and disallowance refer to could not only to those of the Governor General under Section 90 of the BNA Act, and not the power of the Lieutenant Governor, which are at the end when a bill has come an act. Section 11 of the Act provides that when the proposal for repeal of some law has been approved by majority of the electors voting, that law is automatically to be deemed replaced at the end of the 30 days after the publication in the official gazette. Thus, the Lieutenant Governor appears to be wholly excluded from the legislative authority. The initiative and referendum decision related to an act of the legislative, and secondly, to the act being ultra vires the provisions of BNA Act. Ultra virus you can pronounce, or ultra vires you can pronounce. But ultra vires, I think, is more correct pronunciation. This is not at all relevant to the amending power of the Constitution. The Act was found to be invalid because the machinery which is provided for making the laws was contrary to the machinery set up by the BNA Act. The Impugned Act rendered the Lieutenant Governor powerless to prevent a law which has been submitted to voters from becoming an actual law if approved by the voters. The Impugned Act set up a legislative difference from the Constitution by the BNA Act, and this is the legislature has no power to do. So in Canada also, in Great Britain also, legislature don't have power to change the basic structure. Then para 999. Mr. Palkhiwala relied on an Australian decision in Taylor versus Attorney General of Queensland 23 CLR 457 and Victoria versus Commonwealth 45 ALJ 251 in support of the proposition that there is inherent and implied limitation on the power of amendment. How great the Rani Palkhiwala and how great his junior were at that time, who has helped him to search out such type of authorities. In our daily practice, we are getting tired to search out the authorities, citations of the High Court and Supreme Court only. But these people have searched the citations at international level. Such a devotion. When you are in practice in a Supreme Court, High Court, to always remember, give one task to any junior or any intern for that particular task. Search out any recent foreign Supreme Court judgment. Foreign Supreme Court judgment. Maybe Singapore Supreme Court judgment, maybe Japan Supreme Court judgment, maybe USA Supreme Court judgment, maybe Great Britain Supreme Court judgment. Recent judgment, if you cited in your pleading, in your argument, it will great impact. But whole thing we cannot do alone. With the grace of Lord Krishna, I have 13 associate team with me in my law firm. Out of that, 5 are AOR. So due to this team and entrance, some juniors which are connected to us, we are giving them tasks of research. Find out this case, find out that case. So see how I'm reading only specific paras. In 2 days, I cannot cover whole Kesavananda Bharati case. I have covered only Nani Palkhiwala's contentions. And not all contentions, only selected contentions. So studying of this judgment thoroughly is equivalent to read the 50 to 60 books, big books on law. Everything, so many cases you can understand from this judgment like that. Then para 1000, in Taylor case, the Parliamentary Bill Referendum Act of 1908 was challenged. The Parliament Bill Referendum Act provided that when a bill passed by the Legislative Assembly in 2 successive sessions has in the same 2 sessions been rejected by the Legislative Council, it may be submitted by a referendum to the electors, and if upon by them, shall be presented to the governor for his majesty's assent, and upon receiving such assent, the bill shall become an act of the Parliament in the same manner as if passed by the both houses of Parliament, and notwithstanding any law to the contrary. The Australian State Constitutional Act 1907 provided that it shall not be necessary to reserve for the signification of His Majesty's pleasure. Therefore, any bill passed by the legislature of any of the state, if the governor has previously received instructions from His Majesty to assent, does not assent accordingly to the bill. Then para 1011. Mr. Palkhiwala relied on some Irish cases in the support of theory of implied and inherent limitations. 1012, in Ryan case 1935, Irish report 170, the validity of amendment of Article 50 of the Irish Constitution, which came into existence in 1922, fell for consideration. Article 50 provided that within 8 years from the commencement of the Constitution amendments to the Constitution were to be made by the ordinary legislation. After the expiry of 8 years, amendments were to be made by a referendum. The other provisions in Article 50 was that amendment shall be subject to the provisions of the Article 47 of the Constitution. Article 47 made the provisions of the suspension in certain events of any bill for a period of 90 days and for the submission of any bill to suspended to referendum if demand should be made. By the Amendment Act in 1928, a reference to the provisions of Article 47 was repealed. In 1929, before the expiry of 8 years, where there was an amendment of the Constitution whereby the period of 8 years was changed to 16 years. Both the amendments were upheld. Amendments were challenged on two grounds. First, that many articles of the Constitution are so fundamental as to be incapable of alteration. Second, Article 50 does not authorize any change in these fundamental articles. Friends, this is the argument or judgment of 1973. At that time, internet was not there in our country. Internet movement, computer, everything will be happen after 1980-81, after the Prime Minister of Rajiv Gandhi. And even though in that print era, to find out such type of citation, find out such type of arguments point is maybe a very great task. So such a type of personality we can remember after 100 years or so. So this is the great thing. And I want to give you one information on Nani Palkiwala National Law Clubs. 16 groups are there on WhatsApp. 2 our official groups are there. Nani Palkiwala National Law Club, official 1, official 2. That is the official group. So those who are the member of that group, they are the treating as a member of Nani Palkiwala National Law Club. So we have a Nani Palkiwala National Law Club or near about 1,500 members. No entry fee is there for Nani Palkiwala National Law Club. No entry fee, no annual fee. Just you be a part of that our official group. Apart from that official group, we have that official group is restricted for admin notification only. But apart from that, I have started 16 different groups. That is Nani Palkiwala National Law Club Criminal Law Discussion Group, Nani Palkiwala National Law Club NPNLC, short form, NPNLC Corporate Law Discussion Group, NPNLC Service Law Discussion Group, NPNLC Armed Forces Law Discussion Group, NPNLC Legal Language, those who want to improve illegal language like me, because I'm basically from Marathi medium and I have taken education in vernacular language basically. Then in LLB only, I studied in English. So it is the our need of the hour to improve your English daily. So one group is there also. One group is for tracking also. Nani Palkiwala National Law Club. With the work of legal, we getting so much botheration, we getting so much pressure. To relax that pressure, we have started that trekking group also. We have started national international trip group also. So be a part of that group. And one more thing, in the first week of January, I will appoint one chairman and secretary to each of that 16 groups who will look after that group. It is not possible for me to look after all the activities of Nani Palkiwala National Law Club, because I'm a thoroughly practitioner lawyer in Supreme Court of India with 13 my associate through my law firm. And with the grace of Lord Krishna, I published more than 61 books on Supreme Court case laws, which are available on Amazon and Flipkart also. Just put Jayprakash Somani books there. You will find my all books on Supreme Court case laws. High courts, all near about all advocates, high courts near about judges, majority judges are using that books. Many law schools are using that. Very, very, very reasonable prices. So this is our task. And what is our mission? So whatever that all 16 groups are discussion group. You can put your impression, you have everything, but no salutation, no greetings, no festival greetings, no birthday greetings, nothing there. Only which is related to that particular group. So I will appoint one president and secretary for each group in the January, first week of January 2025. That time that group will take it. So that group will decide. If that group is deciding to take a physical get together, we will arrange physical to get together. So if you are the fund of this Nani Palkewala National Law Club, then I invite you to come on 16th January to that grand program. And all groups link, every links, all group link. If you don't have any, all the 16 group links, okay, then just a message to my PA, Pooja Rai, 9322188701 number. You have that, Pooja Rai and number. Just a message her, okay, send me the 16 different Nani Palkewala groups joining link. You will get that links. And in which subject you are interested, join that group only. Don't join all the groups. If you are interested in criminal, you are interested in corporate, if you are interested. As a Supreme Court practitioner, we have to give attention to all areas. I'm handling service matter, I'm handling corporate matter, I'm handling insolvency matter, I'm handling SEBI matters, I'm handling NCLT matter, I'm handling consumer forum matter, National Consumer Forums matter. I'm handling Competition Acts matters. I'm handling service matters, I'm handling army matters. I'm handling all matters with the help of my 13 juniors, 13 associate, and including 5 AORs are there. My 4 books on AOR also there on Supreme Court AOR on my Flipkart or on Amazon platform. So AOR drafting book is there. AOR leading cases, 64 cases, leading cases group is there, book is there. And along with that, in a video also, on YouTube also, 64 cases in four part. I have covered 64 cases. Those who are appearing for AOR examination, 64 leading cases there. So we are doing at our best. But if you are fond of such type of work, you join us. And today I'm in Pune, and I'm going to take one press conference on 1st January. And in that press conference, I am taking in Pune, for Pune and Maharashtra people, free legal camp, free legal guidance camp I am taking. If you are from Pune, if you are junior or if you are enter, just a call to Pooja Rai. I want to join to serve in this mission. Pooja Rai will take your some information and she will give you the chance. You come to press conference in Patrakar Bhavan, Navi Pet, Pune. You record that. You help me in that if you are interested. Then on 4th January evening at 4:30, we have kept in Pune, in Maudhan, in my residence, my Bangalore, one physical session of free legal guidance camp. We Supreme Court law are always taking fee 5,000, 10,000, 25,000 cases for consultation only. But it is our moral duty also to arrange some camps which is free of cost for general public. As a practicing lawyer, I am handling only after High Court's matter only in Supreme Court. But it is my duty to guide to lower court matter also. So I am taking this camp on the banner of Nani Palkewala National Law Club. So on 4th January, I am taking physical camp in Pune. And on 5th January, I am taking virtual camp for all Maharashtra people. Virtual link will be there. Really, if you are interested to join me physically, you can join me physically. If you are nearby in Pune, you contact my PA, Pooja Rai, on 9322188701 number. And those who are not able to attend that, you can join virtual also on 5th January. How I'm conducting that? Legacy should go ahead. Now I'm running 61 friends. Maybe I, with the grace of Lord Krishna, I maybe practice up to 80, 85, 90 maybe. But what is after that? I'm observing Nani Palkirwas in you. I'm observing Ramjet Malani in you people. Yes, you are task personalities. We cannot handle 3 to 4 works at a time, but you people are handling because you are young generation. Utilize your time in proper ways. Don't see WhatsApp at 5 minutes interval. Keep some limitation to see WhatsApp. Keep some limitation to see the emails in a day. Focus on reading. Focus on thinking. Focus on discussing. And focus on the welfare of your client. Don't focus on money. Put your excellent. Money will follow automatically. It is my life's experience, friends. If you focus thoroughly for the benefit of your client and to help the court to give the decision in proper way. In my argument, I sometimes show my negative point also to court. These are my negative point, Lordship. But I have the explanation for this negative point in this way, in positive ways. They are very happy at that time. Because I'm helping judge to decide the case. As a lawyer, we should not be a mouthpiece of our client only. We are not Katputli of our client. We are the friend of court also. Amicus jury also. We are a friend of court. So we should do that also. We are a noble profession, friends. Noble profession. Those who are focusing daily and reading daily at least 2 to 3 hours law, judgment, discussing, watching videos. I have created one play group in my on YouTube channel. Jayprakash Somani Law Play Group hai, in my YouTube channel. My YouTube channel, Jayprakash Somani. If you put on YouTube Jayprakash Somani, you will find my channel. In that channel, there are so many groups, play groups. In one play group, Jayprakash Somani Law, which lectures I like, I selected that lectures and put that. You will find Nani Palkirwala's original lectures are also there. You will find Ambedkar's original lectures are also there. You will find D.Y. Chandrachud lectures are there. You will find R.F. Nariman's lectures are there. We find Datar Sir's lectures are there. You will find my friend Kapil Sibbal's lectures are there. Which lectures, which podcast, which discussions I like, I have segregated into that law, particularly that Jayprakash Somani law play group playlist. So you can take that benefit also. So this is our endeavor, friends. Okay. And then now I am moving towards concluding session now. (1608), Mr. Palkhiwala also replied upon the speech of Dr. Ambedkar made on September 17, 1949 in the Constituent Assembly to show that fundamental rights could not be taken away or abridged by an amendment of the Constitution. The question whether speeches made in the Constituent Assembly are admissible to ascertain in the purpose behind the provision of the Constitution is not free from doubt. In A.K. Gopalan versus State of Madras in 1950, Kannaiah, Chief Justice, said that while it is not proper to take into consideration the individual opinion of member of parliament or convention to constitute the meaning of a particular clause which a question is raised, whether a certain phrase or expression was up to the consideration at all or not, a reference to the debate may be permitted. In the same case, Patanjali Shastri judge said that in construing the provisions of this act, speeches made in the course of the debate on a bill could at best be indicative, indicate, INDICATVE, indicate of the subjective intent of the speaker, but they could not be reflect the inarticulate mental process laying behind the majority vote which carried the bill. Mukherjee just said that in the constituent a provision in the constitution, it is better to leave out the account of debate in the Constituent Assembly, but a higher value may be placed on the report of drafting committee. Very good remark given here. And then concluding part, my conclusions are briefly these. This is not my conclusion. This is the conclusion of the judges of at that time in Kesavananda Bharati case. First, the decision of leading majority in the Golaknath case that the then Article 368 of the Constitution merely prescribed the procedure for the amendment of the Constitution, and that the power of amendment had to be traced to entry 97 of the list 1, Schedule 7, read with Article 245, 246, and 248 is not correct. Second, the decision of the leading majority and of the Hidayatullah judge that there is no distinction between an ordinary law and the law amending the Constitution is incorrect. Article 13.2 took in only ordinary laws, not amendments to the Constitution affected under Article 368. 3. The decision of the leading majority and of the Hidayatullah judge that Parliament has no power to amend the Constitution so as to abrogate or take away fundamental right is incorrect. The power of some dissenting judgment, some ascending judgments, okay, because this case was decided as a 7-6, okay. So 7 has given the ascended judgment and 6 has given day. But in some descended judgment also, good, some principle you will find very good. And descending judgment also, Parliament has passed some laws on dissenting opinion also in future. That is the requirement of that particular time. We are a very responsible professional person, friend. It is in our hand, in advocates' hand, the democracy of our country. So we should be very aware of day-to-day happenings in our country. Preamble, fifth, preamble is a part of the Constitution and is not outside the reach of the amending power under Article 368. 6. There are no inherent limitation on the amending power in the sense that the amending body lacks the power to make amendment so as to damage or destroy the essential features or the fundamental principles of the Constitution. 7. The 24th Amendment only declared the true legal position as it obtained before that amendment and is valid. Point 8. Section 2A and Section 2B of the 25th Amendment are valid, though courts have no power to question a law described in Article 32.2 substituted by Section 2A and Amendment Act, on the ground that the amount fixed or determined for the compulsory acquisition or requisition is not adequate, or that the whole or any part of such amount is to be given otherwise than in cash. Court have the power to question such a law if 1, the amount fixed is illusory, or 2, if principles any are stated for determining the amount are wholly relevant for fixation of that amount, or 3, if the power of compulsory acquisition or requisition is exercised for collateral purposes, or 4, if the law of compulsory acquisition or requisition offends the principle of constitution other than the one which is expressly accepted under Article 31 to be introduced by Section 2B of the 25th Amendment Act, namely Article 19(1)(f) or 5 or V, not 5 or V, if the law is in the nature of a fraud on the Constitution. 9. Section 3 of the 25th Amendment, which introduced Article 31C into the Constitution, is valid, in spite, however, the purported conclusiveness of the declaration therein mentioned. The court has the power and the jurisdiction to ascertain whether the law is for giving effect to the policy of the state towards the securing principles specified in Article 39B or C. If there is no direct or reasonable nexus between such a law and the provisions of Article 39B or C, the law will not, as stated in Article 31C, receive immunity from the challenges under Article 14, 19, or 31. I will arrange a separate seminar on these articles, separate webinar on this Nani Palkewala platform on Article 49, 19, 31, 21, 20. Then last point in this, point 10, the 29th Amendment Act is valid. The 2 Kerala Acts mentioned therein, having been included in the 9th schedule, are entitled to be protection of the Article 31B of the Constitution. I would direct each party to bear its own cost. As I am coming to the close of my judgment, drafting of the judgment of several of my esteemed colleagues are trickling in. As I took at them, I hear a faint whisper of Lord Julian, and then I thought I began the judgment by saying that I wanted to avoid writing a separate judgment of my own. Our first thought is best. The view by the majority in this writ petition is as follows. So what is the final decision? What is the final output of this case of 13 judge bench, larger bench, this case 7:6? What is final output? That final output is this: Golak Nath's case is overruled. Article 368 does not enable Parliament to alter the basic structure of framework of the Constitution. So this is a doctrine of basic structure. Section 2A and B of the Constitution 24th Amendment Act 1971 is valid. The first part of Section 3 of the Constitution 25th Amendment Act 1971 is valid. The second part, namely, and no law containing a declaration that it is for a giving effect to such a policy shall be called in question in any court or the ground that it does not give effect to such policy is invalid. The Constitution, the 29th Amendment Act 1971 is valid. The Constitution bench will determine the validity of the Constitution 26th Amendment Act 1971 in accordance with law. The cases are remitted to the Constitution bench for the disposal in accordance with law. There will be no order as to the cost incurred upon to this stage. And final order, The Constitution Bench will determine the validity of the Constitution 26th Amendment Act 1971 in according to with law. The cases are remitted to the Constitution Bench for the disposal in according with law. There will be no order as to the cost incurred upon this stage. How great these things. Let me tell you, 69 days continuously, this argument was held in Supreme Court during 6 months' time. And Nani Palkiwala was coming there to argue these cases from Bombay. Early in the morning, he woke up at 3 a.m. Before 3 a.m. also, because he has practiced to give the appointment to some client to meet him at 9:30 a.m. in the morning, because after that at near about 4 a.m. he have to leave for the airport. And after reaching airport, he caught the flight and come to the Delhi to argue the case. And then in that week, 1, 2, 3 days continuously, he was staying in hotel or whatever government has given that facility and stay there. So such type of a busy work there. Every day, how much efforts these people are taking. See towards our judges. See the lifestyle of our judges of High Court and Supreme Court. Some district courts also. Some judges are very busy. In our court, in my court, Supreme Court of India, all judges have a very exhaustive schedule. Early in the morning, at around 8:30, they started their work at their home office. They have 2 offices, home office also, in court also. They have 2 PAs. Home PA is also here. Home staff is also there. Yeah. Full setup is there. They started their reading everything, their thinking, their telephones, their emails at 8:30 a.m. They are coming to Supreme Court near about 9:30. They are reading, they are discussing, and on bench they are sitting at 10:30 by observing the briefs. And they are, when you are observing the arguments of the Supreme Court, you will find judges are well prepared. Afternoon 1 hour is there for lunch. Many times they are not taking that 1 hour also. They are taking only 14 to 15 minutes only. But sometimes averagely 1 hour is there. And at 4:30, at 4 p.m., our benches now end their argument session or hearing session. But after that, while sitting in chamber, they are dictating the judgments. Sometimes they are in the court at 8:30, 9 p.m. Such type of exhaustive schedule. And even though some judges carrying some files at home also at reading night time. See the devotion of these peoples. We should learn from these peoples. All, each and every judge of my court is very efficient, friends. From different corner of the country, they are coming here. Many of them are the chief justices of state high courts. Some of them are elevated directly from bar to bench. They are very, very luminary lawyers in that particular their era. So I wish same thing to you. You also enjoy the law. I'm enjoying law, friends. I'm enjoying law. I'm not taking botheration of the law. I have no BP, no sugar, nothing else. But when I go, in Pune, I have the car and everything. In Delhi, I don't have the car. My junior have the car. My 3 juniors have the car. I have not purchased the car in Delhi because I'm staying in Delhi alone. So I just walk 5 to 7 minutes. Metro station is there. New Ashok Nagar metro station, near to Mayur Vihar. New Ashok Nagar metro station. Then 4, 5 metro station. Supreme Court is there. During the metro traveling, I find the time to read. During return journey, I also find time to read. But when I'm in Pune and when I'm traveling to Pune by my car, that time is getting waste. So I'm always putting some law videos, so law audios on that tape recorder. And while I journey, I listen the law video, law conversation, utilize each and every time. While I am in fresh up at morning in Commode also, on Commode also, law book is there in my hand because we are Bombay side lawyers. We don't have a single time to waste, friends. I hope I want to create what is the mission of my Nani Palikiwala National Law Club? To create a legal luminaries, to recognize the efforts of the legal luminaries, to recognize some senior advocates' efforts and to give them lifetime achievement awards, to recognize the work of the judges and give them some awards, to recognize the work of the junior young lawyers, their dedication to give them the excellent award. And continuously legal education process is there. Averagely, we are taking minimum one program every week. And sometimes 2-3 programs also happen in a week online, because online platform and all the online platforms program are recorded and we have put them on YouTube channel. So permanently they are there. So such type of top, this 8-day series is a top. It is a top. So these 8-day series, very, very heavy language, very paragraphs, very heavy cases, different Supreme Court cases you are hearing. You are hearing here. But repeatedly, you will get chance to hear again and again because of YouTube channel. So take that benefit also, friends. So thank you very much for attending these. Yeah? And there are some members who are lasting till this time, this webinar. So thank you very much. And see you for our next third session of this Nani Palkiwala Jayanti series. Thank you very much.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं, जो Amazon और Flipkart पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें, ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।